discussion, we can say discharge of contract. So one of the normal mode of discharge of contract is by discharge of performance. So in addition to that, some other mode of discharge of contract. So discharge of contract means see, both the parties are terminated, or both the parties are terminated from their contractual obligation. So in that case, we can say discharge of contract is there. So a contract is discharged, terminated, when the rights and obligations created by it comes to an end. So whenever the rights and obligations arises due to a contract come to an end, we can say that contract is discharged. So a contract is discharged by the following ways. So the normal way of discharging a contract is by performance. So in addition to that, there are other ways in which contract also discharged. So these are the following ways in which contract may be discharged. The first one is by performance. The second one is by attempted performance. The third one is by supervening impossibility. Then next one by mutual agreement, by lapse of time, by operation of law, by breach of contract. See, these are the 7 ways in which a contract can be terminated or discharged. First one is by performance. The second one is by attempted performance. The third one is by supervening impossibility. The fourth one is by mutual agreement. The fifth one is by lapse of time. The sixth one is by by operation of law. And the seventh one, last one, we can say breach of contract. So let us see one by one. The first one is discharge of contract by performance. So this is a normal way, general way in which a contract come to an end. This is by performance. When both the parties to an agreement, or when both the parties to a contract performing their obligations, so in that case, naturally that contract come to an end. So this is by fulfilling the obligations of both the parties. So in that case, we can say the contract is discharged by performance. The next one is by a tender or by attempted performance. So in this case, when the promisor makes an offer of performance or tender and the other is not accepted. So in this case, the promisor is ready to execute the contract, but the other party, the promisee, he is not in a position, he is not ready to accept the performance. So that means one party is ready to fulfill his obligation, but the other party is not ready to accept the performance. So such a type of performance, in that case, one party is promisor is in a position to perform the contract. So such type of performance or discharge of contract, we can say by attempted performance or by tender. Then the third one is by supervening impossibility. That means for what purpose we created a contract, that particular thing is becomes impossible due to certain reasons. By vis major or due to certain reasons, the act becomes impossible. So the supervening impossibility will occur two cases. First one is impossibility at the time of contract. Section 56 specifies that the impossibility at the time of contract. That means whenever we are making the contract, that particular thing itself is impossible. See, such type of contracts are void ab initio. And second one, impossibility of performance will occur, impossibility at the time of the contract. The second one is impossibility, subsequent impossibility, or supervening impossibility. So supervening impossibility or subsequent impossibility means the possibility of performance of the contract becomes impossible, or the performance of the contract becomes impossible because of some vis major or some out of control. See, this is not in the hands of the promisor, and such type of impossibility will be called as supervening impossibility. And whenever in case of such kind of supervening impossibility occurs, such kind of contract will be treated as void. See, in English law, law, this supervening impossibility will be called as doctrine of frustration. For example, A and B contract to marry each other, and before the time of marriage, B becomes mad. See, the contract becomes void. See, this is an example of supervening impossibility, because when at the time of making the contract, the possibility of performance was there, and but due to certain reasons, or because which are out of the control of the promisor or promisee, some act happened and one party is unable to perform the contract. So such type of impossibility will be called as supervening impossibility. In English law, supervening impossibility will be called as doctrine of frustration. The supervening impossibility may arise in the following cases. First one is destruction of the subject matter. The second one is when the foundation of the law ceases to, when the foundation of the contract ceases to exist. The second one is due to change of law, the death or personal incapacity of the person, or declaration of war. See, these are some of the cases in which supervening impossibility will come. The first one is destruction of the subject matter due to certain reasons like earthquake, tsunami, fire, etc. So in that case, that performance of the contract becomes impossible, and it will be treated as discharge of contract by supervening impossibility. The second one is when the foundation of the contract ceases to exist. For what? So for what we are, for what purpose we are making a contract? The foundation of that contract right now not existing, or it ceases to exist. So in that case also, that contract is discharged by supervening impossibility, or change of law due to the changes in law in any of the countries the contracting parties are residing. So sometimes the performance of the contract becomes impossible. For example, suppose maybe the contract is related to export or import, foreign trade, or export or import of goods. So in a specific country, maybe the import, it is that particular component, it is listed in the prohibited list or negative list. So in that case, that importer is not in a position to import goods because of the government restrictions, because they put it in negative list. So due to the changes in customs law, etc., the performance of contract becomes impossible. So it will be that contract ceases to exist mainly because of the supervening impossibility. The next one is death or incapacity of a person. For example, suppose we are depending the skill and expertise of a person. So suppose we are depending the skill and expertise of a person, the death or incapacity, or personal incapacity of that person, that automatically ceases the existing contract. That means we can say due to supervening impossibility, that contract ceases to exist due to death or personal incapacity whenever we are depending the skill and expertise of a specific person. And last one is declaration of war. See, whenever the war broke out, see, in that case the one country will declare the other country as alien enemy, and the transactions between these two countries will become illegal. And in that case also we can say that contract is discharged by supervening impossibility. See, these are some of the instances in which supervening impossibility will come. First one is destruction of the subject matter. The second one is when the foundation of the contract ceases to exist. The third one is due to change of law. The fourth one is death or incapacity of a person, and last one is declaration of war. And the next one is there are certain exceptions to the principle of supervening impossibility. Some cases, we are not in a position to escape by using the term called as supervening impossibility. That will be coming under the term exceptions to the rule of supervening impossibility. So that means supervening impossibility is not an excuse in the following cases. The first one is difficulty of performance. See, so the difficulty of performance is not an excuse. Sometimes the contract is, we are in a position to execute it, but it is little bit difficult to perform it. So that difficulty in performing a contract is not an excuse. So because it is possible to perform, but it is only difficult to perform only. The difficulty to perform a contract is not an excuse or not an exception to the we cannot exercise the rule of doctrine of supervening impossibility in case of difficulty of performance of contract. The second one is commercial impossibility would not discharge a contract. See, sometimes it is commercial, a contract would not deemed to be impossible because it does not remain profitable to the promiser or would make the promiser to incur losses. Sometimes it is commercially impossible. It is possible, but commercially impossible in the sense that, see, suppose we are executing that contract, maybe our profit will be less, or maybe we are incurring losses. So in that case, that less profitability or incurring losses, that is not an excuse for escaping from contractual obligations. The next one is strike, lockout, civil disturbances, rights, etc. This is also not an excuse from execution of a contract. See, in case of strike or lockout in plan, that is not an excuse for escaping from the contractual obligation. So that supervening impossibility is not applicable in case of strike and lockout in plans, etc., or in production process. The next one is partial impossibility. See, sometimes in some contract, the performance of the contract partially it might be impossible. So in that case, whatever partially impossible means partially possible. That means whatever things which are partially possible, that should be performed. See, these are some of the exceptions to the general rule of supervening impossibility. The first one is difficulty of performance is not an excuse, not to escape from contractual obligations by using the supervening impossibility. The next one is commercial impossibility is also not an excuse from discharging the contract. Strike, lockout, and civil disturbances, etc., rights, etc., is not an excuse just like escaping from contractual obligations. And partial impossibility. In case of partial impossibility, see, where a contract is entered into for more than one purpose, the contract would not become impossible if one of the object has become impossible to achieve. So whatever things achievable, whatever things possible to execute, that should be exercisable. See, these are the exceptions to the rule of doctrine of what we can say supervening impossibility. Okay, the next one, the next discussion is consequences of supervening impossibility. In case of supervening impossibility, what will be the consequence? The first one is supervening impossibility makes a contract void. See, whenever supervening impossibility occurs, that contract will be treated as a void contract, and the parties are discharged from their respective obligations of the contract as per section 65. So whenever a contract becomes supervening impossible, in that case that contract becomes void, and the parties involved in this contract will be treated as discharged from contractual obligations, and the party who received any advantage under it should be restored to the other party. The other means, see, that any party out of this contract received any benefit out of this contract, that should be restored to the other party. This is the effect of supervening impossibility. The first one is the contract becomes void, and the parties involved in this contract, they are discharged from the contractual obligations, and the third one is any party received any benefit out of this contract, that should be restored to the other party. This is the effect of supervening impossibility. Then these are the discussion about the discharge of contract by supervening impossibility. The third one or fourth one is mode of discharge of contract, we can say by mutual agreement. By agreement between the contractual, the parties involved in a contract, they can discharge the contract. And the discharge of contract by mutual agreement may be in any one of the following ways, or termination of the existing contract by mutual agreement may be in any one of the following ways. The first one is by novation. So novation means substitution of existing contract by a new contract. So whenever we are substituting, we are introducing a new contract instead of an existing contract, such type of discharge of contract we can say by novation. So when a new contract is substituted for an existing contract, either between the same parties or between different parties, it is called as novation. So novation means substitution of an existing contract by a new contract. So this contract may be between the parties involved in this contract, this existing contract, or by existing parties involved in this contract, and some new parties are also involved in this contract, in the new contract. So this is one of the another mode of discharge of contract, we can say by mutual agreement, by novation. The mutual agreement may be another mode of discharge of contract, we can say alteration. By altering, by way of making some material alteration in the existing contract, we can say we are in a position to discharge the existing contract, and a new contract will come into existence. So when one or more of the parties of the contract are changed, one or more of the terms of the contract are changed or altered, in that case we can say that existing contract is discharged and new contract came into existence. This is another mode of discharge of contract. The next one is by rescission. Rescission means when both the parties to the contract, that means rescission means cancellation of the existing contract. See, both the parties decided to rescind the contract, both the parties decided to cancel the contract by mutual agreement, we can say the rescission occurs. So that means the contract ceases to exist. Another mode of discharge of contract is by remission. See, when one party to a contract is ready to accept lesser performance from the other party, so in that case we can say remission occurs. So remission means one party is ready to accept the lesser performance from the other party. So in that case that existing contract is discharged. For example, Mr. A owes to Mr. B 500 rupees but pays only by Mr. A is owing to Mr. B 500. Mr. B is saying that okay, I am ready to satisfy this settling this claim just by receiving rupees 200. See, in that case this is actually remission occurs. That means the promisor he is ready to accept the lesser performance of the contract in order to discharge that contract. The another mode of discharge of contract is by of waiver. See, any one of the parties or both the parties involved in this contract are ready to waive some of the terms and conditions or some of the contractual obligations. So in that case we can say the waiver occurs. So when a party to a contract abandons his rights under the contract, the other party is released from his obligation. So in this case one party is ready to waive his rights from the out of the contract. So in case waiver occurs, the contract will be treated as a discharge. Another one is merger. See, in case of merger, a superior right is merged with an inferior right. So in that case merger occurs. For example, Mr. A, he is using he is a tenant, he is using the house property of a landlord, and for a rental of 5,000 per month. Later on, Mr. A, he outrightly purchased that house property from the landlord. So in that case, Mr. A's position is right now, instead of from tenant to landlord only. That means his right is merged with a superior right is an inferior right is merged with a superior right. So in that case, merger occurs. See, these are the ways in which contract is discharged by mutual agreement. The next one is by lapse of time. See, this is due to by lapse of time. This is due to the application of the Limitations Act. As per Limitations Act in India, see, some contracts will be treated as discharged by operation of law because of lapse of time, because we are not in a, see, suppose one person is not making appropriate steps, legal steps to recover the money, so it will be automatically discharged by lapse of time, or by Limitations Act it will be treated as discharge. And the next one is by operation of law. This covers the following situations like death, insolvency, etc., of the concerned parties. So these are the ways in which a contract will be treated as discharged. Okay. ഒരു സെക്കൻഡ് ക്ലോസ് ചെയ്യണോ? തുടങ്ങാം. The next mode of discharge of contract is by breach of contract. So any one of the parties, breach of contract means non-performance of the promise by the promisee or the promisers. In case both the parties or any one of the parties in this contract they are violating their respective obligations or non-performance of their obligations, so it will result in the breach of contract. So whenever there is a breach of contract, the aggrieved party in this contract is having some rights. So what are the remedies in case of breach of contract? The remedies in case of breach of contract we can discuss, or breach of contract maybe we can discuss in two heads. One is actual breach of contract, and second one is anticipatory or constructive breach of contract. The first one is actual breach of contract. When a person fails to perform a contract, when the performance is due, the other party can hold him liable for breach. Actual breach of contract means when a person is liable to perform the contract on a particular time, he fails to perform the contract. So in that case we can say actual performance is it. This is occurring at the time of due date only. At the time, suppose we fixed a time period, maximum or ceiling limit is fixed, and at the time of due of performance of the contract, maybe the promisee or the promiser failed to perform the contract, we can say actual breach of contract occurs. And second one is at the time of performance is due. Sometimes at the time of performance, when a party to a contract fails to perform or refuses to perform his obligation, at the time when the performance is due, he is committing a breach of contract. And sometimes it will be during the performance of contract. When the contract is being performed, the promiser failed to perform the promisee to accept the remaining part. So that will be called as during the performance of the contract. That means this is partially executed and partially not executed. See, some certain portion of the contract is executed, and the remaining part is maybe the promisee or the promiser is not ready to accept that performance. See, these are the cases actual performance will come. The next one is anticipatory breach of contract. When a party to the contract before the date of performance arrives he repudiates his liability, or he is cancelling the contract. See, such type of contract will be called as anticipatory breach of contract. Or he is doing something. See, this is actually when the one party just before the time of execution of the contract, he is doing something against the execution of the contract, which that performance becomes unable or impossible. See, such type of impossibility or breach of contract will be called as anticipatory breach of contract. For example, so anticipatory breach might be expressed or implied. Maybe he is expressly is violating the provisions of the law, or suppose he is doing some by implied some actions and all. Maybe he is indicating that that particular performance becomes impossible. For example, A promises to marry B in the month of April, but in the month of March A marry C. See, in this case, actually there is one contract. A promises to marry B in the month of April, but just before April, in the month of March, A marries with C. That means the agreement with A and B, or agreement between A and B is impossible. So in that, this will be treated as an anticipatory breach of contract. So in case of anticipatory breach of contract, there are two remedies are there. The first one is the aggrieved party, he is in a position to wait till the maturity time, or he is in a position to file a case against other person even before the maturity time of the contract. So consequences of anticipatory or constructive breach of contract. The first one is he may treat the anticipatory breach as actual breach of contract and can cancel or rescind the contract. The second one is he may ignore the notice or the conduct of the promisor, or the act of the promisor, and may wait till due date of the performance. And if the promisee is not performed, he may treat it as a breach of contract. So there are two options. The first one is whenever he is knowing this anticipatory breach of contract, he can immediately rescind the contract and go ahead sue for damages. The second one is he can the aggrieved party can wait till maturity time, and suppose it is not performing, so he can he can treat it as breach of contract and file a case against the other party for claiming damages. See, these are the consequences. And